Hi, everyone. We're here today with another panel in this series. Today, we're going to be talking about immigrant visas and non-immigrant visas and how they relate to each other and how one affects the other. This is an interesting topic because we have so many clients that come to us and people have different plans. You know, maybe right now you've got the plan to be a student, but in the future, maybe you've got a relative in the US who's petitioning you to immigrate to the United States. And all of this goes into the consideration of the visa officer when they're looking at your application. So I know that there's there's a lot of information on the internet and there's a lot of misinformation on the internet. And we want to make sure that you've got all the information you need to make your plans for how you're going to submit your petitions, to submit your visa applications, and do it in a way that's not going to get you in a bind and cause you unnecessary problems during your visa interview. My name is Ben. As you know, I'm a former visa officer with the US government. I worked in Guangzhou, China, and in Bogota, Colombia. I was a visa officer in the immigrant visa unit, the non-immigrant visa unit, and the fraud prevention unit. I did over 60,000 visa interviews of every conceivable type. And I have with me today two colleagues who also were former visa officers. I'll let you introduce yourselves. Krista, would you like to begin?
Hi, I'm Krista. I worked in the consulates in Mexico City and in Guatemala City, and also had some short experiences also in Santo Domingo and Guadalajara. Happy to be here with you guys and talk about this very interesting topic.
Hi, I'm Anna. I'm a former visa officer in London and in Ciudad Juarez, Mexico. And like the others, I have adjudicated several different types of visas, including e-visas in both of those locations. And I'm also currently an immigration attorney. So I have a pretty wide range experience on this topic as well.
And we're really lucky to have Anna with us today because of her broad experience, both in Mexico and in London, where you see all different types of visas and people from all over the world, and in being an immigration attorney and seeing the petition side of things, where as Krista and I, we mostly worked, as visa officers, so we see the applications once they arrive at the consulate, at the embassy for adjudication, but we've got the full spectrum. Just as a disclaimer, we're not giving legal advice here, but we're talking about the procedures of applying for visas, and hopefully it's going to give you some insight into it and help you out. Okay, so the first question, and it's a very simple one, is do immigrant visa petitions have an effect on your non-immigrant visa application?
Yes, I mean, the short answer to that is most definitely yes. And depending on what type of non-immigrant visa that you're reapplying for, if you're renewing your non-immigrant visa or if you're applying for the first time, depending on where you are in the process of the immigrant visa process, it could definitely cause immigrant intent is what the legal term is. And if you have immigrant intent for certain visa types like H1s and L1Bs and O1s or quasi-dual intent, there's certain visa types where a pending immigrant visa or a pending green card application won't interfere with the renewal of a non-immigrant visa, but in other cases like F1s and purely non-immigrant visas, yes, it absolutely can have an impact on a renewal or on an initial non-immigrant visa application.
Yeah, and I like to always explain to people kind of the why behind that, because they kind of see it as like, well, it's all visas, and I'm doing this now, in the future I'm going to do something else, and why can't it all work out, the way I want it to? But you just have to understand kind of the why behind it in terms of if you're asking for a non-immigrant visa, it means you're asking to go to the United States for a temporary stay. So if you have a pending application for a permanent stay, then the intent behind your temporary stay may come into question. And that's why you need to be prepared to transition this NIV to IV spectrum properly in order to not have any problems with immigration officials.
Yeah, that's a good point. Whenever, in my life, I have my plans and this is what I'm going to do now. And then I've got a plan for later. And so my intent changes, over time. But then you go into your visa interview and everything is right at once, right? That visa officer sees, oh, you're applying for this visa now. And I see that you have a petition for that later. They see it all, it's all happening at the same time during their review. And so what would go into your mind when a visa applicant comes to your window and they're, let's say a student visa, because we've got a lot of student visas applying right now, and they've got an immigrant visa petition in the system that you see? What's the first thought that comes into your mind?
I mean,
They have,
oh, sorry, go ahead.
that they have, some kind of social or work network in the United States. Some family member lives there, is petitioning for them, or they have a pending job offer, or something like that, that says, okay, this person already has some kind of interest in the United States. It's going to frame the context of the interview immediately.
Yeah, I was just going to say, I always advise my clients, legally speaking, the visa officer is supposed to make a decision about what is your current intent right now when you're in front of me at the window, right? I mean, that's what the law actually says. But in practice, a lot of officers, like Krista says, will go far beyond that, right? And they'll look at, is this person going to stay and do OPT, which is perfectly fine, but officers sometimes have heartburn over that. So yes, absolutely, that's going to frame the interview. It is going to, dictate what questions the officer is going to ask you, because they're going to want to dig into that a little bit deeper, especially if it's a family-based immigrant petition, I would say, because that shows that you've got family in the United States and you likely won't come back. Even though it's about what, are you going to be a bona fide student? What is your true intent right now? An officer is likely going to dig into your history and your background a lot more than immigrant visa at the time of the interview.
Yeah, especially if there's a family-based one and you see that it's been pending for 10 years or something like that, that's one thing. At first you just see that there's a petition, right? And so you're thinking, and I think we can probably agree, when you see this, it's not going to be a positive thought that goes off in the officer's mind. The first thought is going to be, they won't think, oh, this is negative, but they're going to think, oh, this is potentially a negative, right? Before they even look into the details on it. It's something that they think will need to be resolved, right? They're going to need to explain why this applicant has an immigrant petition and they also still qualify for this non-immigrant visa. Even some immigrant visa petitions, let's say an EB3 investor immigrant visa, the applicant intuitively, and I 100% understand why this would be the case, intuitively thinks, oh, this should be good evidence on my part. This shows that I'm, an immigrant investor, that I've got the funds to put into this project in the US. However, there is that aspect of immigrant intent that's associated with submitting that EB3 petition. And so if you're applying for a non-immigrant visa, you're going to get that officer who you need to help them resolve this dissonance there with the immigrant petition and then the non-immigrant application that you're applying for right there at that moment.
Yeah, Ben, I was just going to say, immediately when an officer sees a history of a immigrant-based petition in the system, they think this is more work.
Yeah, exactly.
You've got to help them resolve that work.
And there's always the go-to for visa officers around the world whenever they're presented with more work in a visa application, which is to not even do that extra work and just 214B. Unfortunately, that is the case. That's not everyone. And I would say that the majority of my colleagues are 98% of the time very earnest in how they're doing their job, but there's pressure on them from above to do the job quickly. And when they're presented with a bunch of information that they're going to have to sort through, it could just be subconsciously that their brain interprets it in a negative light, because then they can just refuse it and they can move on to the next case. So the best thing to do is don't just leave it in their hands. Don't leave it to fate, leave it to chance. And however that consular officer's mind is going to interpret the facts that they encounter, go in with a plan for how you're going to present your case, your visa history, your pending immigrant petition, how you're going to present that to them so that they know you're holding their hand through it, so that they know, okay, this is why this immigrant petition is pending. This is who put the petition in. This is when this is the date that it will become current. So these are my plans now. These are the plans in the future. Let them know from the beginning so that they're not just kind of, sitting there thinking, I wonder what's going on. I wonder, right? If you know this is something that they're going to wonder about, come in prepared to let them know in a very concise way, this is the situation. If you had an applicant come in and be ready to explain it to you, Krista, how would you respond to that?
Absolutely. I just listening to you talk about, you know, knowing when the visa is going to, or when the petition is going to be current, is music to my ears. And because so many times applicant could be like, oh, I don't know, I think my dad's sister put that application in, and I'm maybe, I don't know, derivative, is that the word, on this application? I don't know when it becomes current. I don't have a plan with that thing. And that kind of nonchalance and just not really knowing or being on top of your own paperwork, it doesn't lend a sense of, I guess, like organization and seriousness to the applicant, which a visa officer is going to be much more, I think, open to saying yes to an applicant in this situation if they are really organized and know what's going on with their petition and know kind of when the dates are and who is the person or what is the entity that put in the petition, what the relationship is, what the future plans are, you know, what if this were to become current, you know, pretty soon, how would that affect the current application that you're having right in front of the officer, et cetera. So being able to connect these dots and having information around them just makes the job of the officer so much easier and gives you as an applicant a more organized and like confident look for them, so that they can say, oh yeah, this person knows exactly what's going on, and they clearly are very serious and aren't going to, you know, just overstay their non-immigrant visa. They know the rules around this.
Yeah, and I would just add, don't think that, you know, I get a lot of applicants, a lot of clients that think that if they're contributing to the US economy, that that's a good thing. And that's the first thing they want to say. Like in the case of EB5, oh yeah, my dad is a millionaire and he has, you know, of course I'm a dependent on EB5 visa application because he's going to pump a lot of money into the US economy. Well, that may be true and that's very relevant for EB5 purposes. But if you're applying for a student visa or a non-immigrant visa, the officer doesn't really care about that. It's relevant in terms showing what your financial status is and that you're probably going to not, you probably are a bona fide student. However, just be a little bit cautious about thinking that, you know, your economic, how you're going to contribute to the economy of the US isn't really what the officer is looking for, right? They're looking to see if you're going to use the visa that you say you're going to use it, you know, that you're using, doing exactly what you're going to say for the visa class that you're applying for, and that you are, you know, going to come back, right? If it is a visa class that's subject to 214B and non-immigrant intent, that's what they're looking for. So I often get clients who mention that their EB5, you know, derivatives right away, thinking that'll be beneficial to their case, where in some cases it's not. In some cases it actually harms your application. So just be aware of, you know, the visa class you're applying for and what the officer is looking for that particular class. And then I would just add to what Krista said about, you know, if you do have a petition that's based on, you know, a derivative petition from a brother or sister petition that you may not even know about. I often ran into those as a visa officer in London or in Mexico too, because Mexico, you can be waiting for 15, 20 years, right, to have a visa petition come current. And so you may have aged out in the process and you may have forgot about it. Well, ask your family before you go and be aware of what might be in the system, because if the officer sees that, like both Ben and Krista said, you're going to have to be able to explain that so the officer can, you know, mark that down that they address that in the interview. So just be aware of your own history, you know, and don't be caught off guard by the officer when they ask you a question about, oh, what's this immigrant petition pending here in the system?
That's a really good point. Yeah, I think a lot of people expect that, oh, well, my lawyers took care of that. You know, my lawyers know that, but that's not the case. When you're in the visa interview, you're expected as the applicant to know the details of what you're presenting, what your cases are, right? You can't just say, oh, well, I hired a lawyer to handle this for me. You know, that's their job. No, you have to be the owner of your petition and your application. That's a really good point. There are a lot of cases excuse me, where it's going to be possible to present the information in a good light, right? Like the student that you're talking about who has the EB5, if they go in and they're able to present the information in the right way, and they do have the intent to use their student visa properly, and then use that EB5 petition in the future properly, then the visa officer will grant that visa. You have to present the information in the right way. And when I say present the information in the right way, a lot of times, and it's just a conceptual issue. A lot of times people think it's, oh, well, what do you say what do you do? What paper do you give that allows them to give you the visa? And I want you to know that it's not about saying the right thing or checking the right box. It really is about making that visa officer comfortable and confident that you're going to use your visa correctly. And you're going to do that just by talking to them, right? It's not like going to the driver's license office and submitting the paperwork. And if you've checked all the boxes and paid your fee and you filled out the form correctly, then you get it. That's not what it's like. It's, the person has to want to believe that you're going to use the visa correctly. And so if you can convince them of that, then they can give you the visa. Now that's in some cases, like the one we talked about. We do have some clients who will come to us and actually, we tell them straight up what our assessment is of their chances to get a non-immigrant visa, because in some situations, it's nearly unimaginable that a visa officer would give someone a visa. And I'll give an example. I had a client who was in Nigeria, and her husband had gone to the US on a student visa. And then while he was in the US, he had then put in a petition for an EB3 visa, which is an immigrant petition for unskilled labor in the US. And this was pending. And then in the meantime, he wanted his wife to come over on an F2 visa, since he was still in F1 status. She wanted to come over on an F2 visa as his derivative, while he already had this EB3 immigrant visa petition pending with her as the derivative. She'd been refused once before, and they knew that this was the situation. This is one of those situations where the officer knows that she and her husband have the intent to immigrate permanently to the US because they've already filed the petition and he's already in the US. And so there's no way that a visa officer, knowing this, is going to issue an F2 non-immigrant visa when they know that the intent is to get to the US and then immediately convert to an EB3. Would you agree with that assessment?
I mean, yes, probably, but adjustment of status is in the law for a reason, right? So officers do have issues with it and are concerned about it, even though it's a legal process. So I have to often explain that to my clients, that what they're doing, because they say, we're not doing anything illegal, right? But you have to overcome that bar of immigrant intent at the time of the interview. So yes, I mean, Ben's absolutely right. That's going to definitely be an issue, even though what you're doing isn't illegal, but it's about your intent at the time of the interview. So yes, I think that can be confusing for some applicants, because you're not doing anything illegal. You're applying for a legal visa, adjustment of status. If you're in the United States in valid status, that's a legal process that is legally allowed to do. So I think sometimes people are confused by why is it a problem? Why would I be refused even though I'm not doing anything illegal?
Yeah, the immigration system is not it's not always coherent and agreeing with itself. There's some incongruities there where it's like, yeah, we're going to refuse you if we know that this is your intent when we're abroad, but then once you're in the US, it's a legal process.
Yeah, it's kind of funny, and probably the reason why a lot of that people need a lot of assistance to get through this process, because it really isn't as straightforward as one would hope. And I think to pick up on that, and kind of to go back to what's the why behind this kind of confusing part of the process, I would say that the visa officer is looking at, for example, in your example of the F2 derivative whose husband has a pending immigration or immigrant petition in the system. The visa officer's question in their head is this person actually going to the US to to reunite with their husband as that their husband is studying, or is she just going to use this visa to get to the US earlier to circumvent the process of the immigrant petition? And in some cases, it seems pretty likely that the answer is yes. And so when you go to your visa interview, you want to be very prepared to, have an argument for why you're not trying to circumvent the immigrant petition and the time that it takes. Because unfortunately, the processing times for some of these immigrant petitions is pretty long. It can be as little as 6 months, but it can be, like Anna said, with siblings. If a Mexican visa petition comes in under the category of sibling, it can take up to 15 or 20 years. If you're using the non-immigrant visa, or it could even be perceived that you're using the non-immigrant visa category to circumvent the long processing times of the immigrant petition, that is not going to look favorable in your non-immigrant visa interview. And you're going to want to have a very strong and coherent response to convince the officer that that is not the case.
Yeah. What, if any, effect would non-immigrant visa refusals, let's say you've applied for a tourist visa or a student visa and you've been refused a couple times, and then later you're applying for your immigrant visa petition, what effect will those refusals have on your immigrant visa petition, if any?
I mean, I always tell clients, know why you were refused, and sometimes they're unaware of that. But if it was a 214B refusal, or a refusal that was basically just because they didn't find you qualified for that visa type, then it's going to have little to no impact at all on an immigrant visa. But if it was refused because of a security grounds or medical ineligibility or a prior immigration violation, then of course all those ineligibilities still apply for an immigrant visa. So it completely depends on what the reason the refusal was for. If it was, just because you weren't qualified for, or if it's H-1B refusal because, you didn't show that you had a 4-year degree, so you didn't qualify for H-1B, well, that's probably not going to be relevant for the green card category, depending on what green card category you're applying for. So it all depends on the type of refusal and why you're refused. But most of the time, if it was just, a refusal for a tourist visa or F1, it's not going to have any impact on an immigrant visa application.
What is that dependent on? Is that for every immigrant visa across the board? What if it's like an EB3? Because we do have a lot of clients, and I know that there's a lot of people watching who have pending EB3 petitions, and they might have had some refusals in the past. Because there's a little more discretion for the EB3 in terms of the consular officer's adjudication, how might that have an effect on that adjudication?
I still would say that it's very limited, right? Because you went through, the 3-step process, right? You had to go through the prevailing wage determination, you went through the PERM process, you have an approved I-140. So for an officer to deny the visa at that stage or deny the immigrant visa at that stage, they're going to have to ask for the revocation of the petition. So they're going to have to go back and ask USCIS to revoke the I-140. And that's a really high bar for a consular officer to, unless there's a finding of fraud or there's a finding of something that, a reason that the I-140 shouldn't have been approved initially, it's going to have very little impact on an immigrant visa just because it's a petition-based process. And, there's 3 different agencies involved in the process. So by the time it gets to the consular officer, they're going to have a really good reason. They're going to have to basically show that there was a finding of fraud, or an ineligibility that maybe the USCIS officer wasn't aware of. But otherwise, the burden of proof on the part of the officer is pretty high for them to deny an immigrant visa.
So I would differ with
go ahead, Krista.
I just would differ on that a little bit because I know that there are EB3 applications that go through consulates that are very vigilant about fraud in the EB3 category, and so are very much looking to deny EB3s that are not well prepared, that maybe the applicant doesn't, have responses to the kind of job that they'll be doing, isn't aware of what the prevailing wage is, et cetera. And so, that's another reason to be very well prepared with all the information about your case, whatever consulate you're going to, but especially, and Argo can help with this, about, knowledge about where EB3s are more difficult to get through the consulate. But what I wanted to say about what would be my response to seeing the denial of an NIV, a non-immigrant visa application, if I were to receive, for example, an EB3 petition, I would say, oh, the officer who denied those NIVs was right. This person wants to immigrate to the United States. And now they're in the correct category to do so. So in some senses, it would be favorable in the sense that, okay, now they're following the right process. They have a job offer in the US and they really do want it. That's what they want to do. They want to work in the US. So it makes their whole picture a little bit more coherent if they have a visa denial in the past for, say, a tourist visa.
Yeah, there's a specific category of applicant that I think kind of falls into like a little limbo in terms of where they should be applying, and it's people who intend. It's an American citizen and a non-American who intend to get married, so they're fiancés, but they don't intend to reside in the US. They want to get married in the US and don't intend to reside there, right? So the K visa is technically for people that intend to go to the US and get married and then reside in the US, right? And so many times people will apply for, let's say, a K visa because they want to go and they want to, get married in the US and then they want to, move back abroad. And a visa officer might say, oh, but you don't intend to reside in the US. Or they might say, actually, I'm sorry, let me start that over. If you apply for a B visa, which is actually the proper visa to use to go to the US and get married and then go back to your residence abroad, it actually explicitly says this in the FAM that that's the proper use of the B visa. But if you go into an interview and you encounter, let's say, an inexperienced officer that's relatively new, they're going to think, oh, wait, no, that's K visa. That's wrong, not B visa. And they might refuse you. And so you think, well, I guess we need to do an immigrant visa. And so they do the K visa.
Exactly what happened to my husband.
And they do the K, really. They go to do the K and then they show up, and then the immigrant visa officers that are maybe a little bit more experienced, they look at this and they say, well, do you intend to reside in the US? And you say no. And they say, well, then the K is inappropriate. Now you've been refused an NIV and you've been refused your IV, and the two offices aren't talking to each other, and you kind of get caught up there. So Krista, since you've got the personal experience there, what tips would you have for somebody on how to avoid that from the very beginning?
Well, I think that in any interview that you go into where you are personally, related to in terms of, a sibling or a parent or a spouse or even a potential spouse who is a United States citizen, you should know that you will receive a little bit more questioning and perhaps suspicion about what is your intent in going to the United States as a tourist. So from the get-go, wanting to be super prepared for your interview and knowing your story really well is the best piece of advice you can get in terms, you don't want to say, what are your future, if the officer says, what are your future plans with your fiance? Oh, well, we might get married in 2023 and, that's only if his mom is, able to come or whatever. If you're just spouting vagaries about what your plans are, you're probably going to irritate the consular officer, first of all, and second of all, you're not going to be presenting a convincing case to them that you know what your plans are. You're a very serious applicant. In terms of like presenting yourself as a very serious applicant, would equate in the mind of a consular officer, this is a very serious person who doesn't have any intention to intentionally violate immigration law. There's someone I can trust to use this visa well. And so eliminating any kind of vagary from your responses is the first and I think most important piece of advice for someone who has close relations in the United States, to eliminate any kind of suspicion that they're going to use those close relations in the United States to stay permanently through the wrong process, basically.
Mm-hmm. When I've had clients that have been in situations like this one with the people intending to marry in the U.S. but not reside there, or any other situations, one was a medical school student who was going to do some of their rotations in the U.S. at a hospital, and the visa that they were applying for was a B visa. They'd been refused because they said, no, you need a J visa for that, when actually in the regulations, medical clerkships are a valid use of a B visa, not a J visa. So what I do, because we know from our time as visa officers what most visa officers are going to know about, right? We know what they know. They don't know every single regulation. They know the most commonly applied regulations. but they do want to do their job correctly. And so if they're aware that this regulation shows that this is the type of visa that someone should be using, they're going to apply it correctly. So when I've got clients like this, I will go to the Foreign Affairs Manual, which is publicly available and anyone can access this, except it's not very user friendly, and we just have the experience using it and we know how to find these regulations. And I will take that regulation in the exact format that it is in the Foreign Affairs Manual, that the consular officers are used to seeing it in, and have them print that out so that they can take it in and say, well, you know, I've actually done some research and I think I'm applying for the right visa class. I've got the regulation right here for you to review. And when they see this and they can look it up and confirm it, they're going to think, oh, well, I thought that was a J visa, but I guess it is a B2. Or I thought this should have been a K visa, but I guess the B visa is the appropriate one. So that's what I call like hand-holding the consular officer through the process. They're trying to go fast, right? Then they cannot be as thorough as they would like to be with every single applicant. So make their job easy. Show them exactly where in the regulations they are allowed to give you the visa that you're applying for.
I would agree with that. I would just add that officers do like to feel like they're in a position of authority. So if you question their training and their knowledge of the FAM, sometimes that can go wrong. So I agree that you need to educate the officer, and officers, I always tell my clients, officers get, 6 weeks of training in visa law. And so that's what you're dealing with most of the time. And most of the time when you are going to the window, you're dealing with an officer that's in their first or second tour. So they have very limited knowledge, really. And so if you're applying for sort of something like a medical student or something that's more of a niche area of the law that they probably don't see every day in front of the window, you do want to be prepared to educate the officer, but you want to do that in a tactful way, because you want to make sure of the position of the officer, but at the time, politely tell them that they may not know exactly everything and that you have prepared something to sort of educate them, but you don't want to say.
I'm sure you heard the way that I phrased that. I didn't say this is the regulation that says you should. I said it in you have to be very humble, right? You have to recognize their 100% authority to make that decision. Officer, I did some research. I think I'm applying for the right visa category. Here's the regulation I found. If you'd like to review this, always deferring. This is you're trying to achieve your purpose, right? You're not trying to show up the officer or make them recognize that they were incorrect, right? It's all about achieving your goal.
Yeah, I wouldn't print that piece of the FAM up and just slap it on the window before you open your mouth, which I think some people feel like doing sometimes. Just, I know I'm doing the right thing. Here's the regulation. Let's just get this, get through this. But yes, there's a lot of tact that goes into it, and, making sure that you're approaching the interview in the way that the consular officer wants to be approached.
Definitely. There's finesse involved in it, because you're dealing with people that are 100% earnest and are wanting to do their job as best as they possibly can, but they do not have the time, resources, and they may not have been given the training that lets them do that as well as they want to. So it's perfectly appropriate to help them in that way, but you always have to keep in mind the way that you do that is important as well. Thank you so much for being with us today, Anna and Krista. I appreciate it so much. I'm sure our listeners and our watchers appreciate it too, getting your perspective from around the world on how NIVs and IVs react with one another and how one affects the other. If anybody has any questions, write to us in the comments and we'll respond to you, or send us an email at hello@argovisa.com. That'll be in the description of the video as well. Thanks for tuning in, and we'll keep on putting content out there to help you pass your visa interviews. Thanks, everybody.